All right, well, let's continue along with Section 3, Business Torts. The book notes that torts can usually occur in any sort of aspect, but there's a select few amount of torts that deal with wrongful interferences of a business relationship. The book talks about wrongful interference with a contractual relationship. Three elements are necessary for wrongful interference with a contractual relationship to occur. First, a valid contract must exist. Second, a third party must know that this contract exists. And the third party must intentionally induce a party to the contract to breach that contract. So what do I mean, for example? Let's say you run a shoe business and you have one supplier of shoes and that supplier gives you a discount for your shoes. Well, you have a competitor who opens up the street. We'll call him Steve. He opens up Steve's shoe shops right down the street from yours, and he wants your vendor. He knows that you have a contract with this vendor to get your shoes cheap, so he goes to that vendor and basically says that you are stealing money from him, from the vendor. And then the vendor breaks the contract he has with you because of this information that Steve gave him. That's a perfect example of wrongful interference with a contractual relationship. Now, how is this different? For example, if Steve had no idea that you had a contract to buy shoes from this vendor and Steve was just talking bad about your company to this vendor, then that's not wrongful interference with a contractual relationship because he must know that a contract exists. So be careful if this question comes up, especially on the midterm. Wrongful interference with a business relationship. Business persons devise countless schemes to attract customers. They are prohibited, however, from unreasonably interfering with another person's business in attempts to gain a greater share of the market. There is a difference between competitive practices and predatory behavior, the book notes. Actions undertaken with the intention of unlawfully driving competitors completely out of the market. Attempting to attract customers in general is legitimate business practice, whereas specifically targeting the customers of a competitor is more likely to be predatory. For example, the mall contains two athletic shoe stores, Joe's and Sprint. Joe's cannot station an employee at the entrance of Sprint to divert customers to Joe's by telling them Joe's will beat Sprint's prices. Doing so would constitute the tort of wrongful interference with a business relationship because it would interfere with the prospective economic advantage. Such behavior is commonly considered to be unfair trade practice. If this type of activity were permitted, Joe's would reap the benefit of Sprint's advertising. Defenses to wrongful interference. I encourage you to read through those because it shows how to defend yourself against some of these items, and we'll be talking about these in class as well. But I want to point out page 88 of the book has a wonderful table actually on the items when we're talking about intentional torts. The book outlines exactly assault and battery, false imprisonment, all the other ones, appropriation. So make sure keep this page in mind when you're studying in the future because it's a wonderful page. Let's go into intentional torts against property. Intentional torts against property deals with several elements. It's an ancient sort of understanding that an individual has a right to protect their property, has a right to the property itself. So it's no longer talking about effects done on a person. We understand sometimes if you hurt somebody, then maybe you should owe them money. But we also have a true understanding that if you somehow affect somebody else's land, then somehow you have done something wrong to them. Trespass is a perfect example. A man's right to his castle, the castle doctrine essentially, even though that's expounded upon, but the idea is that you have this inherent right to your actual physical property that you live on. It's illegal to trespass on somebody's property. The book breaks down trespass as well. Trespass to personal property, conversion, theft, all those items, the idea of stealing something, all those fall under torts. So I'm not going to go through those too much in detail, but I encourage you to make sure to look through them because I'm sure they may pop up on the midterm. But the idea is that torts not only deal with effects done to a person's physical body, but they can also deal with their property, which makes sense. If you steal something from somebody, maybe you should owe them some money because you stole it from them. But a big one now coming up on page 92 of the book is negligence. Negligence is a big item, and the book breaks it down well describing that there are certain elements to be able to deal with negligence. The book notes, negligence suits are probably the most prevalent type of lawsuits brought against businesses today. The tort of negligence occurs when somebody suffers an injury of another's failure to live up to a required duty of care. The perfect example you can think of negligence claim is the slip and fall. The idea is, let's say a grocery store has liquid. Somebody dropped orange juice on the floor and nobody ever cleaned it up. Now somebody's walking by, they slip on the orange juice, they fall. What do they want to do? They want to go ahead and claim that the store was negligent for not cleaning up the orange juice. Now we can go through this case because there may be several issues if the person's entitled to money at all. But the idea is that the store is negligent because they failed to clean up the orange juice. It's up to the judge then to determine, were they truly negligent? Should the person have seen the orange juice spilt on the floor? All those certain items are worked through, but the understanding of what somebody, when they're claiming negligence, is basically that the store should have taken some action to clean up the floor so people wouldn't step on it and spill. So for somebody to win a case in negligence, there has to be 4 main elements that must be met. The first one is duty, that the defendant owed a duty of care to the plaintiff. We see those words, defendant and plaintiff, again. Number 2, breach, that the defendant breached that duty. Number 2 was breach. Number 3 is causation, that the defendant's breach caused the plaintiff's injury. And number 4, damages, that the plaintiff suffered a legally recognizable injury. The book breaks down duty of care, breach, causation, and damages. But to understand them a little bit, duty of care consists of several items. One is the reasonable person standard. So let's visit this again. We're on page 94. Tort law measures duty by the reasonable person standard. In determining whether a duty of care has been breached, for example, courts ask how a reasonable person would have acted in the same circumstances. The reasonable person standard is said to be, though in an absolute sense it cannot be objective. Said to be objective, though it cannot be in an absolute sense. It is not necessarily how a particular person would act, it's society's judgment of how an ordinarily prudent person should act. If the so-called reasonable person existed, he or she would be careful, conscientious, even-tempered, and honest. That individuals are required to exercise a reasonable standard of care in their activities is a pervasive concept in business law. And many of the issues dealt with in subsequent chapters of this text have to do with this duty. This idea of the reasonable person standard is mythical in a sense. That's what the book is saying, is that it is meant to be objective, though in its absolute sense it cannot be an objective element. What we try to do is quantify what it means, taking the average sort of spectrum of reactions to a situation. What is the middle average of those actions? So it's kind of interesting understanding the reasonable person standard, and you guys can help me discuss it in class because it's an extremely important element, because we're taking something that sounds so utterly subjective, trying to make it objective. The book then breaks it down. The duty of landowners, the duty of businesses, obvious risks. I want you to read all of these. I'm not going to go through them now because I think it's important that you read them on your own, because we're going to have some questions in class, and you guys reading this information here on the duty that's owed, especially this orange juice case I just mentioned, will help you understand why I said it may be interesting to see whether the judge will award money when somebody spilled orange juice on the floor. The duty of professionals and no duty to rescue. The duty of professionals. There's a heightened standard for individuals who are professionals. What do I mean? That's usually the case with doctors, attorneys, and things like that. When somebody's a professional, if they've done something wrong to you, it falls into the realm of malpractice. Malpractice is basically alleging this person has a higher standard. They should have been upheld to this higher standard, and since they failed it, this is now an elevated form of duty, and it results in malpractice. No duty to rescue. There is a clear understanding. There is no duty to put yourself in harm's way. You see somebody who's getting attacked, you usually have no duty to respond or to stop the attack. There's no duty to rescue. Causation. The book notes, another element necessary to a negligence action is causation. Causation. If a person breaches a duty of care and someone suffers an injury, the person's act must have caused the harm for it to constitute the tort of negligence. In deciding whether the requirement of causation is met, the court must address two questions, which we discuss next. Is there causation in fact, and was the act the proximate or legal cause of the injury? Now, these are two highly technical legal terms. I want you to read them, but in fact, more importantly, what's going to help you understand is our first case review, which is case 4.2 on page 96. It's the Sawgraff case. In this case, an individual was on a train station patio waiting for the train to arrive. And then a series of unfortunate events, if anybody's seen the movie Lemony Snicket and a series of unfortunate events, it's also a book, but a series of unfortunate events unfolded where this woman who was on the train platform ended up getting hurt. I want you to read through the case, take some notes on it, and be prepared to talk about it in groups on next class, because this is a fantastic case, but it also explains what do I mean by proximate cause and causation in fact. The injury requirement and damages. Usually, and it's one thing, you've been hurt. You've suffered some sort of harm, but are you entitled to money for the harm you've suffered? That's always the biggest key when it's coming with tort law. What are the damages? What have you lost? What is owed to you because of the pain and suffering or the damages that you undertook? So it's always important not just to have an injury, but also have some sort of calculable damages that is owed to you. So it's not just about the injury itself. Yeah, you know what? I touched you. You didn't like it, but what are your damages? Defenses to negligence. This is a good section. Defenses to negligence. And we're on page 97, section 6. Defenses to negligence. There's three. Assumption to risk is the first one. Superseding cause is the second one. And contributory and or comparative negligence is the third. Assumption of risk, the perfect example I always like to use is the roller coaster. Whenever an individual rides a roller coaster, usual assumption of risk is, yeah, I may become queasy and I may throw up all over myself and ruin my clothes for the entire rest of the day that I'm at the theme park. That is a risk that you assume whenever you get on a roller coaster. Now, another risk that you usually don't assume is that something terrible is going to go wrong, i.e., the roller coaster breaks and you fall off and you hurt yourself. You usually don't assume that's going to happen. The first instance, you get sick, ruin all of your clothes, even though it was a super fancy shirt. Guess what? That's usually assumption of risk. You knew that was a possibility of happening. Now, you falling off the roller coaster, usually not a risk that you will assume in the roller coaster instance, and so usually you can probably end up suing for that. Superseding cause is the next defense that the book points to. Superseding cause deals with the fact, you may have caused one injury and then the person may have suffered another injury because of what happens. The book actually uses a perfect example. You run into somebody and you accidentally knock them over. You should have been more careful. They get hurt and they break their leg. Then for some reason, a plane crashes nearby and debris falls on that same person. Now, are you liable to have to pay for the person's injuries for the breaking their limb and also for the damages they suffered because of the aircraft? No. That's a superseding cause. You are probably liable for the fracture that the person suffered, but not for the plane crashing and the damages that they suffered after that. Contributory and comparative negligence. Contributory negligence and comparative negligence deals with how much of this accident was actually your fault. This happens a lot of the times in car crashes, for example, where you have contributory and comparative negligence. But it also happens in issues, let's say you've been drinking all day and you accidentally stepped in front of a car that was driving down the street. If the car was speeding, both of you may be at fault. Number one, you've been drinking all day, you shouldn't have stepped in front of the car. And number two, the car shouldn't have been speeding. So how much of this is your fault? Courts will then look to these things to see, okay, this was 50% your fault and 50% the other person's fault. Let's divide up the money, etc., and we'll work out damages that way. But contributory and comparative negligence looks at the levels of fault, on the different individuals. The books break down pure comparative negligence and modified comparative negligence. I encourage you to read through those as well. I want to finish up special negligence doctrines and statutes. Res ipsa loquitur, which translate into the facts speak for themselves. We also have negligence per se, which is in and of itself. Negligence per se is usually the easiest one to understand. Negligence per se deals with if somebody committed, for example, a violation of a criminal statute, then it's probably automatically assumed they were involved in what is termed as negligent behavior. How do I mean? Let's say a car was speeding down the road and crashed into another car. A police officer comes to the scene and gives the car that was speeding a ticket. That person pays the ticket admitting guilt. That involves automatically negligence per se. The person who was in the other car can usually then sue the person who was speeding for the car crash, and they'll usually get full compensation because fault was already established with the individual. That individual is negligent per se. Read through Res ipsa loquitur. We'll talk about it in class as well. Some of the other ones, the danger invites rescue doctrine, special negligence statutes are good as well to make sure that you understand them. The one last item I want to touch on before we take a little break is the Good Samaritan statute. Lots of states pass the Good Samaritan statute. What is the Good Samaritan statute? It deals with injuries resulting from helping somebody else. Sometimes, strangely enough, you can be liable for stepping in and trying to save someone. For example, somebody fell into a lake, a frozen lake. You jump into the lake and you drag them out of the water, but when you're dragging them out of the water, you break their arm. Now you can say, all right, well, I saved your life. I'm sorry I broke your arm. Strangely enough, the person may be able to sue you for breaking their arm even though you saved their life. I know it sounds kind of crazy, but I'll be posting some interesting websites up there about the Good Samaritan laws and how it works out. California, the book even notes, for example, the only Good Samaritans that are protected under California are actually medical providers. Non-medical providers providing help are not actually protected under Good Samaritan laws. Fantastic point to take a break before we get into our final section, which is section 8, which is cyber torts.